Any memos?
For vacating the stay, emergency.
Alerts,
Friday, maybe.
No, no.
alerts for reporting settlement, my lords. Matter settled tomorrow.
File it.
My lords, A3 has been caused, your lordship. A3 on the parity of A3 has been
70.
caused.
No,
Tomorrow, have it on tomorrow, your lordship.
File it. File it.
Lordship.
File it. File it. Any adjournment?
My lord, serial number 11. Matter is discussed for settlement. My lord, matter we are discussing for settlement, my lord.
1 minute, sir.
Posted after 2 weeks.
I have applied for the certified copies. It will be received by us on 27th. You lost my habit on 27th.
Who's for the respondent?
Respondent HCGP. It has been served and they have not appeared.
Here is counsel for the petitioner pays for short accommodation at his convenience list on Monday. Monday. On Monday, Tuesday. Tuesday.
Yeah.
Yes, sir. Mr. Manjunath.
Yeah, my lord, serial number 11. The petitioner is very much before the court. Yes, madam. We are discussing for settlement, my lord. It may be posted after.
Your is for respondent.
Is for respondents, my lords.
Yes.
Settlement talks are going on, my lords. So,
Counsel for the petitioner and respondent number 2 submit in unison that there is a settlement between the parties, and some more time may be required to report settlement. Hence, list on. Yes. Correct.
This one, serial number 1, pronouncement of order. Hemant Raj, D.F. Prasad.
Petition is dismissed.
Serial number 2, Ashok Nayak, Siddharth Suman.
But I am for the petitioner in this. This is an association which the earlier association in 2021 had filed many cases, which were all frivolous and the thing there. So the present association decided to withdraw all the cases and close it. My lord, I put the memorandum of the minutes of the meeting, page number 13 of memo what I filed. In that there were 11 cases, my lord.
And you have filed a memo seeking withdrawal of the petition. Withdrawal.
This one.
Memo for withdrawal is filed.
Yes, yes, my lord.
Yes. ಆಯ್ತು withdraw ಮಾಡಿ withdraw as the same become infructuous.
Yes, my lord.
Okay. Criminal cases are withdrawn.
Yes, my lord. Page number 13, I just pray to look the page number 13. Unfortunately, there were 12 cases, my lord, 11 cases. That minutes had the association had decided to withdraw all the cases. Now, except this case, all have been withdrawn. So I'm praying that this also is infructuous and redundant. So please, it may be allowed to be withdrawn without any condition, my lord.
Counsel for the petitioner filed a memo seeking permission to withdraw the petition as the same is rendered infructuous. In fact, it is stated that the complainant, who is the complainant?
Company to the Shobha Garrison Apartment Owners Association.
Association.
Yes, madam.
Complainant association has passed a resolution to withdraw various cases that are registered by it. Various cases against whom?
Madam?
Against whom those cases were registered?
No, no more, all are over now.
No, those cases were against whom? Against the
Against my lord,
petitioner?
the company which was started by one of the member,
And in view of
that
the
is
same,
Garrison Royal Housing.
the petition is to be dismissed. Memo and the submission is placed on record. Petition is dismissed as the same is rendered infructuous. Yes.
Serial number 3, CH Hanumantaraya.
I appeal to the petitioner in this matter, Your Lordship. This is a successive bail application by accused number 1 in this matter. Your
Yes.
Lordship.
Accused number 1.
Accused number 1. In all, there are 3 accused persons, Your Lordship. FIR was registered against unknown persons. It was given by a person who actually saw the dead body lying in front of his office. Incident dated 5/12/23. Crime against unknown persons. Investigation continued and charge sheet was filed on 9/3/2024.
Against 1, 2, 3.
1 to 3.
Offense.
Offense 302, 201 of IPC. Accused number 3 was enlarged on bail after 1 year. And accused number 2, who suffers similar allegation as that of the petitioner, is also enlarged on bail by the order of the coordinate bench in criminal petition 15447 of 25.
When this petitioner was arrested,
Petitioner was arrested 3 months after the date of incident.
date.
His was arrested 16/3/24.
Your earlier petition was dismissed.
Yes, Your Lordship. Your Lordships were pleased to dismiss his application considering his antecedents and his late arrest. I produce the order of Your Ladyship. This was rejected prior to the commencement of the trial, Your Lordship. Now the trial has commenced. 7 witnesses, all the material witnesses have been examined. There are 29 witnesses in all.
Whether these 7 witnesses are supported the case?
No, Your Lordship.
No?
There are no eyewitnesses to this incident. The entire case is based on the circumstantial evidence.
What are the circumstances?
Circumstance 1, the major circumstance is CW7, who allegedly say that he last saw the petitioner and accused number 2 along with the deceased. And now that witness has turned hostile.
He is examined as?
PW7.
Then what are the other circumstances?
Other cause, that's the only circumstance because his implication is based on the voluntary statement. Accused number 2 was first arrested and then accused number 3 was arrested based on voluntary statement of A2. The allegation on this petitioner again is that while he was apprehended and while he was taken to point out the place where he allegedly threw a dragger.
1 minute.
Dragger.
1 minute. 1. Who are these PWs 1 to 6?
PW1 is the complainant who saw the dead body. And 2 and 3 are the punchers of the recovery, the seizure of the bloodstained soil and materials from the spot. 4 is the wife of the deceased.
PW3?
PW3 is also a puncher to the material seized at the spot. 4 is the wife of the deceased. And she only says that she had received call from the deceased when he left to Bangalore. And PW5 is another relative of the deceased who identified the body in the mortuary. And PW6 is the friend of the deceased.
6 is wife of the deceased, my lord.
Then 4 yaru.
4 is wife. Four is wife.
relative of the deceased, friend of the
Nodi.
CW6.
He-
PW6
she
friend.
is saying PW4 is the wife.
No, my lord.
PW4 is the wife. I've produced the evidence of all the witnesses.
Rajesh, CW4 is Rajesh, as per my lord charge sheet. Kindly, my lord, page number.
No, she
And
is
PW
examined.
ಇರಲ್ಲ, CW ಇರುತ್ತೆ.
Sorry, my lord, sorry, my lord.
ನೀವು ಬೇಸಿಕ್ ಗೊತ್ತಿಲ್ಲಲ್ಲ.
Sorry, my lord. Yes, my lord.
Huh?
Yes, my lord. Sorry, my lord.
PW ಬೇರೆ, CW ಬೇರೆ.
Yes, my lord.
Then
PW4 is my lord.
who is PW6?
PW6 is a friend of deceased.
ಏನ್ ಹೇಳ್ತಾರೆ ಅವರು?
ಅವ್ರು ಹೇಳ್ತಾರೆ ಬಿಸ್ನೆಸ್ ಮಾಡೋದಕ್ಕೆ ಒಂದು ಅಂಗಡಿ ಹುಡ್ಕೋದಿಕ್ಕೆ ಅಂತ ನಾನು ಅವರು ಬೆಂಗಳೂರಿಗೆ ಬಂದಿದ್ವಿ ಅವತ್ತು ಅಂತ ಹೇಳಿ. Prior 2 days prior to the incident.
He is not the eyewitness.
No, you're not.
He is not the circumstantial witness.
No, you're not.
Then PW7.
PW7 is the one who says he saw deceased and accused number 1 and 2 in the company.
Who are the other witnesses?
Other witnesses are all inquest witnesses and Mazar witnesses. There are no material witnesses to connect any of these incidents to the crime.
Yes, what do you say?
Yes, my lord. First, my lord, the CW1, PW1 saw the body. My lord,
Not the eyewitness.
yes, my lord, circumstantial, my lord, circumstantial.
What are the materials to connect the petitioner to the offense in question?
Yes, my lord.
It is only CW7, PW7.
And CW5, my lord, CW5 examined as PW6, my lord. Kindly, one Subbaya, my lord. He, along with, come from the Tamil Nadu to Bangalore, my lord, to the house of the accused number 1. He partly supported the prosecution case. We came from Tamil Nadu to Bangalore to meet the deceased, my lord. Kindly, the evidence, my lord, CW, my lord, 5 examined as PW6.
Page number.
Yes, my lord. Page number, my lord, 170, my lord. One Subbaya. He says about your first instance, my lord, idu. First, the circumstantial material, my lord.
This witness says he and the deceased came to Bangalore to look for a shop for PW6.
Yes, my lord.
He does not refer to any of the accused. Your Lord.
3 ಜನ ಬಂದು ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರೆ ಅಂತಾರೆ, but not name the accused person.
No, not identified.
Yes, not identified and not name the accused.
So that will help you.
Yes, my lord. I will explain, my lord. First instance, ಬಂದದ ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ. ಎಲ್ಲಿಂದ ತಮಿಳುನಾಡಿಂದ ಬೆಂಗಳೂರು
Early, sir.
ಬಂದದ.
ಬರೋದ್ರಿಂದ
Yes,
ಏನಾಯ್ತು?
next, my lord. Next, I will take, my lord. The 161 statement of the CW7, my lord, PW7, my lord, is last in, my lord. He is clearly, categorically stated about
About the evidence before the trial court.
he is turned hostile, my lord.
Then
But in 164 statement, clearly, categorically stated.
register a complaint against him.
Yes, my lord. Then, my lord, the wife of the deceased stated about phone call on the same night when the incident taken place. The same night he called the deceased until along with the accused number 1 ಜೊತೆ ಇದ್ದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹಾಗೆ ಎವಿಡೆನ್ಸ್ ಹೇಳಿದಾರಾ?
Yes, my lord.
ಅದಕ್ಕೆ ಏನಾದ್ರು ಎವಿಡೆನ್ಸ್
ಅದಕ್ಕೆ ಕಾಲ್ ರೆಕಾರ್ಡ್ ಏನು ನೋ ಮೆಟೀರಿಯಲ್, my lord. No CDR and no.
There may be several materials, sufficient materials. But what is the material to connect the petitioner to the offense in question? ಅದನ್ನ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು ನಿಮ್ಗೆ.
Yes, my lord.
So many witnesses may so many things.
But ಬಂದದ ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ, only oral
Is it sufficient to convict the accused?
material evidence is very required, my lord. Moreover, my lord, is rowdy sheeter of JP Nagar station. There are 12 cases, my lord.
That is why his bail petition was earlier dismissed.
Yes, my lord. There are 4 302 and 3 307 and one more, my lord. Police sought, my lord, when recover the weapon, the separate crime registered and my lord, matter is pending, my lord. My lord, even the apex court also declined to grant special petition to file appeal against
Yes,
this
earlier
order.
there are materials, sufficient materials. Now, only circumstantial evidence, PW7,
Yes,
not supported.
not supported.
Then,
But he is the rowdy sheeter.
ತಗೊಳ್ಳಿ.
There are 12 cases. my lord.
ರೌಡಿ ಶೀಟರ್ಸ್ನೆಲ್ಲ ಒಳಗಿಡಬೇಕು ಅಂತ ಕಾನೂನು ಇಲ್ಲ ಸರ್.
And injury, there are 7 injuries. At the instance of the voluntary statement, ಇದೆ ಅಷ್ಟೇ 2 and 3.
ಅರ್ಥ ಆಗ್ತಾ ಇದ್ದೀನಿ.
Yes.
ಸುಮ್ಮನೆ ಇದ್ಬಿಡ್ಬೇಕು. ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡೋ ಕೇಸ್ನಲ್ಲಿ ಮಾಡಿ.
Yes.
ಸುಮ್ಮನೆ ಇಂಥದ್ರಲ್ಲಿ ವೇಸ್ಟ್ ಆಫ್ ಟೈಮ್ ಇದೆ ಅಷ್ಟೇ.
Yes.
ಅವ್ರು ಹೇಳಿದ್ದೇನಾದ್ರೂ ನೀವು ಒಪ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅದು ಡಿಸ್ಅಗ್ರಿ ವಿತ್ ಹರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯು ಕ್ಯಾನ್ ಆರ್ಗ್ಯೂ.
ಇವರಿಂದ ರಿಕವರಿ ಇಲ್ಲ. 2 and 3 ಇಂದ
ದೇ ಆರ್ ಆಲ್ರೆಡಿ ಎನ್ಲಾರ್ಜ್ಡ್ ಆನ್ ಬೇಲ್.
Yes.
Paragraph 4, same earlier petition. 5, same. 6, same. 7, same. The charge sheet came to be filed citing CW7. CW7 is examined as PW7. is it?
PW7.
CW7, a circumstantial witness, he has given statement that he had last seen the deceased in the company of accused number 1. The said witness is already examined before the trial court as PW7, but he has not supported the case of the prosecution as he has turned hostile. Next, it is stated that PW1 is the informant who had seen the dead body and filed the first information upon which the FIR was going to be registered. PW2 and 3 are his partners or witnesses. PW4 is the wife of the deceased. PW5 is the relative of the deceased who identified the dead body of the dead body. PW6 is the friend of the deceased. The evidence of none of these witnesses connect the petitioner to the offense in question. Next, it is stated that statement of PW7 was recorded before the learned magistrate under section 164 of CRPC, where he categorically stated regarding the circumstance when he saw the deceased in the company of the accused, but he has not chosen to support the case of the prosecution when examined before the court. The prosecution is at liberty to proceed against PW7 if he has given a go-by for his statement under section 164 of CRPC while deposing before the court. Next, it is stated that incriminating materials were recovered at the instance of accused numbers 2 and 3. They are already enlarged on the. It is further stated that the other witnesses who are required to be examined before the trial court are either inquest or mahazar witnesses or official witnesses. Under these circumstances, I am of opinion that no purpose would be served by detaining the petitioner in custody. It is stated that the petitioner was a rowdy shooter having several criminal cases registered against him. Considering the said fact and also in view of the statement of CW7, now examined as PW7, similar bail petitions filed by the petitioner. Bail petition filed by the petitioner in criminal petition number 5960 of 2024 was came to be dismissed today, order dated 18th July 2024. But under now the changed circumstance, the petitioner is entitled to be enlarged on bail as his detention in custody would amount to infringement of his right to life and liberty. Reasonable conditions may be imposed. Allowed.
Serial number 4, M. Umesh Murthy, Rohit.
For the respondents in this case, my lords. My lords, so we pray for 1 week's time to file the objections, my lords.
Last date also, my lord, that takes time, my lord.
My lords,
This is for default, my lord.
the petitioners before the trial court, my lords, they are delaying the proceedings by taking repetitive recall and adjournments, my lords. My lords, we want to place the conduct of the petitioners on record before this.
What is the stage before the trial court?
For arguments, my lords, now.
No, my
But during the arguments, they are recalling the stage of cross-examination, my lord.
Evidence of the witness is over.
My information is, my lord, cross of PW1, that is CW1. My lord.
My lords, after it was posted for arguments, they recalled it, my lords. They are delaying the proceedings by filing repetitive.
Initially, the witnesses are examined.
Yes, my lords. PW1 was, yes, my lords. Then later, instead of PW1, PW2 was placed on record. But PW2 is not cross-examined, my lord. It is taken as nil by the trial court, my lords. We want to place all that on the record before this.
Let her file objections. Counsel for respondent raise her hand to file statement of objections on the ground. Objections to IAs 1 and 2 of 2026. She submits that the examination of the witnesses before the trial court was over and the matter was posted for arguments. At that stage, the application for recalling the witnesses are being filed. Deliberately, the proceedings is being delayed. Hence, for filing objections to IA 1 and 2 of 2026. File the objections along with material documents. Yes,
Grateful, my lords.
next.
Serial number 5, Pooja Katimani.
Before the trial court, my lord, the stage is for charge.
Charge,
Oh.
not yet framed.
Illa.
Heard learned counsel for the petitioner and learned HCGP for respondent. IA1 on IA1 and 1 of 2025 and 1 of 2026. Filed for recalling the order dated 11/6/2024, dismissing the petition for default, that is for non-prosecution, after condoning the delay of 383 days in filing the application. It is noticed that the petition is of the year 2020. The office has raised several objections. The same were not being complied with, even though the matters were listed formally as elections. In spite of that, the office objections were not complied with. Now it is stated that due to inadvertence, by mistake. Found is by mistake you could not comply with the office objection. Huh?
Please, my lordship.
State the office objections could not be complied with. The same cannot be accepted as a reasonable ground. Looking to the age of the petition and non-compliance of the office objections in spite of lapse of more than 4 years. However, if the order impugned is not if the petition is not restored, the petitioner may suffer as he is not in a position to put forth his contention on merits. Hence, I am of the opinion that the IAs may be allowed subject to deposit payment of cost. Accordingly, I will proceed to pass the following. IAs 1 of 25 and 1 of 26. First two, IA 1 of 26 is allowed. Delay of 383 days in preferring the appeal is condoned. The order dated 11/6/2024 is recalled. The petition is restored on file subject to deposit of cost of ₹5,000 with High Court Legal Services Committee within 7 days from today, failing which the petitioner is not entitled for the benefit of this order. If on deposit of the cost, the criminal petition shall be restored on file. Yes.
Please, my lordship. Meanwhile, my lordship, I'll pay the fine amount.
But may I request for Monday, my lordship? I'll comply the office objections.
Only after deposit of cost, it will be restored. Otherwise, it will
Please,
not.
please, please.
Yes.
Much obliged.
You have complied all the other office objections?
ಮಾಡಿದ್ರೆ ಮತ್ತೊಂದು ಸರಿ ನಾನು ಚೆಕ್ ಮಾಡ್ತೇನೆ. I'll just verify.
ಅದನ್ನು ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ಎಸ್ 6
Serial number 6, S. Rajshekar, Rajaram Suryambai.
For respondent number 2, my lord. In this case, my lord, last occasion, the advocate for petitioner submitted that, my lord, they are agreed to pay a sum of rupees 1 lakh as compensation, my lord.
ಏನಾಯ್ತು ಇವಾಗ whether settled or not?
I obtained the instructions from the party, my lord. They are agreed to obtain rupees 1 lakh as compensation.
That may be,
File the memo.
please. ಅಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡ್ಬೋದು.
ಅಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಏನು ಅಂತ
ಅದು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿದೆ,
ವಾಟ್ ದಿ ಸೆಟಲ್ಮೆಂಟ್ ಇಸ್.
ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿದೆ ಅಂತ ಹೇಳಿ ಇದರಲ್ಲಿ ತೋರ್ಸಕ್ಕೂ ಕಷ್ಟ ಆಗತ್ತೆ.
ಆ ಟರ್ಮ್ಸ್ ಅನ್ನು ಯು ಹ್ಯಾವ್ ಟು ಬೋತ್ ಆಫ್ ಯು ಶುಡ್
Payment, my lords, may even take it as paid also, my lords, from my end, not an issue.
No, both of you should discuss
Yes,
as to what are the terms of settlement.
please. We will file joint memo.
Then file a memo.
We'll file joint.
Joint memo.
Please,
On the
please.
basis of the joint
Yes,
memo, I'll
yes.
dispose of.
Yes, we'll file it. We'll file it.
You know, pass over agenda.
ಅಲ್ಲ, ಬೇಡ ಅವರಿಗೆ ನಮ್ಮ ಸ್ವಲ್ಪ ಇದಿದೆ. He is not yet recovered, I think.
Yes, when will you report settlement, sir?
27th, my lord. 27th.
27th?
August.
Yes.
August.
Yes.
Please.
Great. Interim order.
Yes.
Number 7,
ಆಯ್ತು ಸೆಟ್ಲ್ ಆದ್ಮೇಲೆ ಇನ್ನೇನಂತ.
ಬೇಡ ಆಗದಿದ್ರು ಮಾತ್ರ ವಾಪಸ್.
serial number 8, Kamaluddin, M. Sriram.
Yes. Again a question.
Question.
Respondent number 2, Mohammed Arun Rashid.
Sriram.
ಇವ್ರು ಯಾರು ಇಬ್ರು ಇದಾರಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಗೆ.
Yes, obtain NOC, Sriram.
ನಾವು ಆನ್ ರೆಕಾರ್ಡ್ ಶ್ರೀರಾಮ ಮತ್ತೆ ಇವ್ರ ಹೆಸರು ತೆಗಿಬೇಕಲ್ವಾ? ಮೊಹಮ್ಮದ್ ರಶೀದ್. Absent, let him come. ಅಲ್ವಾ ಕರೆಕ್ಟ್? ಇನ್ವೋಸಿ ಯಾರು ಶ್ರೀರಾಮ್ ಹಾಕಿದ್ದ ತಗೊಳ್ಳಿ. Then counsel Shri M. Sriram filed wakalat for respondent number 2 with NOC from the earlier counsel. Hence office is directed to delete the name of so and so in the cause title, in the cause list. ಅವ್ರು ಇಲ್ಲ ಮತ್ತೆ ಸುಮ್ಮನೆ ಪಾರ್ಟ್ ಆಡ್ ಮಾಡಿಬಿಡೋದೇನಿದೆ. ಐ ವಿಲ್ ಅಜೆಂಡ್ ಬೈ 3 weeks.
ಅಂದ್ರೆ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ, some of the clients who are there, my lord, in the husband also is before my lords. There are other relatives who have brokered the marriage. They are also made parties. Now they are not able to travel because of the criminal case pending.
Since 2021 it is pending, sir.
How? There was an interim order, so it went on, it did not reach. So many things happened. Now at least I'm able to.
ಅಷ್ಟೇ.
It's 498A and
maybe, but
I do understand. Can it be a shorter date, my lord, sir?
Shorter ಅಂದ್ರೆ
Next week ಎಲ್ಲಾದ್ರೂ
11th of March. 10th or 11th of March. Even 10th earliest ಅಂದ್ರೆ ಅಷ್ಟೇ. That is the only way.
ಹೌದು, earliest date ಕೊಟ್ಟು.
Learned counsel for respondent number 2 is absent, no representation. Counsel for the petitioner submits that there is urgency in the matter.
Please.
Hence, counsel for respondent number 2 is directed to address his arguments on the next date of hearing. List finally the last chance, 10th or 11th. Yes.
Please, great.
Serial number 9, A. Prakash Reddy.
Interim order, kindly be. Please.
Appearing for the respondent, my lords.
Counsel for the appellant is absent, no representation. Counsel, you are for respondent.
Respondent, my lords.
Respondent is present. This time. Yes. Next date, okay.
Serial number 10. Kirtana Nagaraj, S. Rashekar.
Lord, I seek a short accommodation, Lord. The petitioner is an advocate to seek instructions from him.
Counsel for the petitioner, place time.
Okay, for respondent, my lords, I'm not coming in the way of adjournment. Only look at the conduct of an advocate, my lords.
What
Who
is the
should be,
conduct?
my lords, always above my lords board is my respectful submission.
Then now ideal situation. Adu. We never see that, unfortunately.
Statements ನೋಡಿತ್ತು ಅಂತಾದ್ರೆ
And
page
place-
8.
I know, counsel for the petitioner, place time. Then at counsel for respondent opposes the move, respondent number 2 opposes the move, saying that the petition is of the year 2022. And the IA 1 of 2025 is Allah. Respondent number 1 and 2. Then at HCGP for R1, then at counsel for respondent number 2 oppose granting of time on the ground that the petitioner is enjoying the benefit of the interim order since 2022. IA 1 of 2025 is filed seeking to vacate the stay already granted. Considering this position, the learned counsel for the petitioner undertakes to address his arguments on the next date of hearing without fail. Submission is placed on record, list finally as a last chance. No further adjournments.
Please.
Serial number 11, Arjun. 12, Omkaran.
Date of
11th March.
ಇದು ಯಾಕಿದು?
The petitioners are the accused number.
ಇಲ್ಲ, 26th night. ಅದು ಇವಾಗ ಇನ್ನಲ್ಲ. ಇದೆಯಾ? Yes, I'll issue notice to respondents.
Meanwhile,
It
stay.
takes notice for
Accept notice.
respondent. Number 1, issue notice to respondent number 2.
Meanwhile, stay maybe, my lord.
Stay ಏನಿಲ್ಲ. Stay ಯಾಕೆ?
ಅದರಲ್ಲಿ ಇನ್ನೂ ಅವೈಟ್ ಆರ್ಡರ್ಸ್ ಒಂದು ಚಾರ್ಜಸ್ ಇನ್ನೂ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದು ಅನ್ನೋನ್ ಪರ್ಸನ್ ಎಗೇನೆಸ್ಟ್ ಟು ದಿ 8 ಮೆಂಬರ್ಸ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Huh?
ಅನ್ನೋನ್ ನಂಬರ್ಸ್ ಅಂತಾನೆ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ
ಇಲ್ಲಿ
ಕಂಪ್ಲೇಂಟ್.
crime is of the year 2019.
ಹೌದು ಸರ್.
Now 26 ಗೆ you have approached this court.
ಎಸ್.
Where is the question of stay?
ಇನ್ ಸ್ಟೇ ಇದು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇನ್
6 years you managed.
earlier 2 proceedings have been stay, my lord. Accused number 7 and 8 those stay.
ಆಯ್ತು. This petitioner who is now approaching the court.
Yes.
Then after 6 years.
Yes.
Let them come.
Meanwhile, my lord.
ನೋಡೋಣ. Earlier petitions ಎಲ್ಲ ಅಲೋ ಆಗಿದಾ?
ಅಲ್ಲೂ ಹಾಕಿದೆ.
ಅದಕ್ಕೆ ಇವಾಗ ನೀವು ಬಂದಿದ್ದೀರಾ? In the meantime, heard learned counsel for the petitioner and learned SCGP on IA 1 of 2026. Initially, the FIR was going to be registered against 4 to 6 unknown persons. CW 2 and 3 are said to be the eyewitnesses. It is stated that no test identification period was held by the investigating officer before filing the final report. It is stated that the criminal proceedings against the co-accused are already quashed. Considering all these facts and circumstances, I deem it appropriate to allow IA 1 of 2026. Accordingly, I is allowed interim model stay as paid till next date of hearing. Yes. Pay PF for issuance of notice.
Yes, ma'am. I'll pay.
Madam ಹೇಳಿರ್ತಾರೆ starting.